It now gives me great pleasure to introduce our keynote speaker, the Honorable Diane Wood, long-time antitrust law expert, very thoughtful jurist, and right here in our backyard. So I think one of the beautiful things of being in Chicago and where we are is that there's so much synergy between the different stakeholders, not just in IP, but also in IP and antitrust law. And I think increasingly this dialogue is important as the two worlds collide. The need for thoughtful rules, the need for thoughtful dialogue. And we have our panel, but before that, to set the stage, please join me in welcoming Chief Judge Diane Wood.
Thank you very much, Daryl. Thank you to the Provost. It's a real pleasure to be here this morning, to be in the position of sharing some thoughts that I've had about this intersection, or as Professor Lim put it, the collision between IP and antitrust. I like the idea that this law school is both very old, it's been around for a long time, and that this new relationship with UIC is there. It's, in a sense, it's kind of a metaphor for what we're doing with antitrust. Our antitrust laws have been around for 130 years. Our IP regime, arguably since the dawn of the Constitution, since Article I provides for protection of the useful arts, etc. So how do they relate, and do we need to rejuvenate them? I'm not so immodest as to think that I can give you a full answer to that question this morning, but let me throw out a couple of thoughts that I've been having about this issue. What, on the one hand, is the procedural interface between antitrust and the different types of IP laws, the patent laws, copyright, trade secret, know-how, and what kinds of intersections do we see on the substantive side? I do think that there are reforms that would be helpful, particularly in the procedural side, but maybe on the substantive side as well. So let's just take a look at it. So in today's world, there is a current and very lively debate, I'll come back to it later, in antitrust, about whether we have in fact struck the right balance over the last 40 years between intervention and restraint. The last 40 years has represented a time when we feared type 1 errors, false positives, more than type 2 errors, false negatives. So we said, well, if we accidentally identify something as prohibited by the antitrust laws, we're removing that practice from the menu that businesses have for structuring themselves. And if we made a mistake about that, then maybe that was a bad thing. Whereas people said, if we allow something to go forward, even though there's, of course, a cost to the economy from that, the processes of competition will move forward, markets will change, and maybe that false negative will prove not to be so harmful in the end after all. So that philosophical perspective has led both regulators and courts to a relatively passive approach to particularly certain kinds of things that fall within the antitrust laws. Exclusionary practices, what might be called around the world dominant firm behavior, monopolistic behavior, we would say, and mergers. It's not been completely hands-off, but it's been a fairly cautious intellectual approach. But some people are now arguing that that's been mistaken. Or they say, well, maybe that was okay in the economy that we had during the 20th century, particularly the latter half of the 20th century, but it's not suitable anymore. It's not adequate. Maybe more needs to happen for the vast concentrations of power that can arise almost overnight in the 21st century's industries. These are industries that are, we call them tech, we call them IP-based, whatever you want to say. So what do we think about this? Well, there might be a good argument for some tweaking, and I'll remind you of the old adage of an ounce of prevention being worth a pound of cure. In antitrust, If you intervene before market power has arisen, you can probably do it pretty effectively. You can stop a merger from taking place. I can think of some telecoms mergers that fit that pattern. You can address concerted behavior under Section 1 of the Sherman Act. You can do something, and you can preserve competition as it is in the market. Once you have a tight oligopoly, just a very few firms, or even more significantly, once you have a monopolist, as we would define it, somebody maybe with more than 70% of the firm and little entry and high barriers and all the rest of that, the tools for fixing them, those kinds of problems, are quite limited. They're really quite hard to deal with. And they're hard to deal with whether you're talking about conventional property, blackacre, so to speak, or whether you're talking about IP. Now, what do we think about IP? The general rule has been for many years, and I think this is entirely correct, that intellectual property is property. It's not some magical other thing that gets extra benefits that property doesn't get, regular property, and it doesn't have any disadvantages either. It's just harder to define. So if you own blackacre, you can build a fence around it and you can exclude other people from using it. But the process of defining and excluding for intellectual property really depends on a legal substrate. It depends on what you're trying to do. This audience certainly doesn't need a review of what the different types of intellectual property cover. So this insight that property is property, whether it's intellectual property or not, is reflected, for example, in the federal agencies, the Department of Justice and the Federal Trade Commission guidelines for the licensing of intellectual property. Those guidelines were first issued actually when I was, this is a long time ago, when I was still at the Department of Justice, when the economic deputy in the Antitrust Division was Rich Gilbert. And Rich toiled long and hard, as did his colleagues at the FTC, as did many others, to put those guidelines together. There's now a new edition out as of 2017. But both of them make the important point that for the purpose, this is a quote, for the purpose of antitrust analysis, the agencies applied the same analysis to conduct involving intellectual property as to conduct involving other forms of property. And importantly, and in contrast with, let's say, what you might have seen in the 1960s, the guidelines say that the agencies do not presume that intellectual property creates market power in the antitrust context. 2 points are worth making. First, there was an old notion that the agencies have been trying now for 25 years to debunk, that anyone with a patent or a copyright, et cetera, had a, quote, monopoly in the antitrust sense of that term. Well, that's plainly not right. Whether there is a monopoly or whether there's not a monopoly depends on the usual criteria. Are there substitutes for this product or process? What's the price elasticity of demand? What kinds of supply elasticities are there? In what market does it compete, et cetera? Just the regular things that you would ask about. So some inventions are just a participant in a highly competitive market, others may not be. And then the second point is that, as the federal agencies recognize, the fundamentals of antitrust analysis are the same. The other thing, maybe the answers are a little different. So I will offer a couple of things, and some of you will have heard me say this before. Darrell mentioned what's really happening is that intellectual property is really all over, and so we need to understand it in light of actually all of our laws, including our antitrust laws. Let's step back for a minute. Who talks about patents or copyrights or trade secret or know-how anymore? There has been an understanding for a long time that intellectual property itself is a whole, and it ought to be understood that way. It shares the features of being intangible. It shares the features of being the product of somebody's inventive thought. It shares the fact that it's hard to put it on the table and look at it. It needs special kinds of treatment. But that's not what we do as a procedural matter. As a procedural matter, we have carved patents off and put them in one corner, and we leave everything else in another corner, copyright, et cetera, et cetera. So these, it seems to me, are individual silos whose time has come and gone. And so what I'm getting to is the fact that if there's litigation about this thing, clearly there's a different administrative structure. We all understand that. But if there's litigation, it starts for all of these kinds of properties in the federal district courts. They have exclusive jurisdiction over patent and copyright cases. They share their jurisdiction with the state courts when it comes to trademarks. Trademarks are kind of funny anyway. They may or may not fall within this category. But basically, you go to the federal district court. Then what happens? If you want to take an appeal, and it has to do with a patent, meaning that the case arises under the patent laws or there's a compulsory counterclaim under the patent laws, off you go to the federal circuit. If it's any other kind of IP, off you go to the regional court of appeals that covers the area where the district court was. And that gives us a very choppy system. It prevents courts from being able to think of IP as a whole. The federal circuit is a disadvantage because it doesn't get the rest of IP. The regional courts are at a disadvantage because they don't get the rest of IP. And it turns out there are all kinds of cases that deal with patents more generally that don't go to the federal circuit. So one example is if there's a dispute over a license for a patent. A licensing dispute is just a licensing dispute. That doesn't go to the federal circuit unless somebody's worried about, whether the patent should have issued or whether it was infringed or something. A license might be about, did you pay the royalties on time? Did you meet performance expectations? Are you selling in areas you're not supposed to sell in? Whatever it may be. And there's actually an old case by one of the great judges we've ever had, Henry Friendly, T.B. Harms against Eliscu in the copyright area, that makes this point. I love this quote, so I'm just going to share it with you, although I know I'm getting short on time. He says, "A layman would doubtless be surprised to learn that an action wherein the purported sole owner of a copyright alleged that persons claiming partial ownership had recorded their claim in the Copyright Office and had warned his licensees against disregarding their interests was not one arising under any act of Congress relating to copyrights. Yet precedents going back for more than a century teach that lesson, etc." So licensing disputes go to the regular courts of appeals, even if they're about copyright, patent, what have you. Another lacuna in this is, notice that the statute says compulsory counterclaims for patents. Well, what about permissive counterclaims? I discovered, actually somewhat to my delight, that permissive counterclaims go to the regional courts of appeals. So I had the fun of dealing with a case called ABS Global against Ingaron, in which I took a deep dive into questions such as patent obviousness and enablement and all of that for a process that sorts bull semen into X and Y groups. So if you're a dairy farmer and you want to be inseminating your cows, you want the X's, right? What's the use of these males? They're not going to help for your dairy farm. Maybe other people want the Y's. I don't know. Apparently, it turns out the X's are more popular, but the women in the room will understand that. So anyway, I had a ball. It was great. It was fun working on this case, and I didn't think it was any harder or less hard than many other cases I get. So the permissive counterclaims are out there. So the bottom line is, as I've suggested before, I think that we should change the regime for the Federal Circuit appeals, fix the uniformity problem using the Judicial Panel on Multi-District Litigation so that only one court has authority over any one patent at any time, so you don't get conflicting results about patents. And that you make the jurisdiction an optional choice. That's true in many areas. So for example, the National Labor Relations Board, if you want to take an appeal from an NLRB action, you can either go to a regional court or you can go to the DC Circuit. Let the parties choose. That allows the development of different thinking around here, and I need to find my you probably know these grim statistics, but what I will say, oh, here it is. So the Supreme Court has suffered from the lack of diversity of thinking in this area, I'm going to say. If suffered means they've been taking a lot of cases. So since 2000, the court has affirmed the Federal Circuit in these kinds of cases 11 times. So that's 27.5% of the cases it took from that court. And it has vacated or reversed, in part at least, 29 times, 72% of the time. So I know, as a judge on a regional court, that there are other views out there that I have to grapple with them, I have to answer them, and if there's a conflict in the circuits, the Supreme Court will take it and they'll sort it out. But if it were only our court talking to ourselves year after year, I think it's just proven not to be as effective. So that's my procedural suggestion, that we really allow IP to be viewed as a whole in the tribunals which are responsible for its development. My substantive suggestion, which I'll be quick with, really comes from some reflections I've had based on the new literature in this area. You may know this literature. John Baker, for example, has recently published a book called The Antitrust Paradigm, Restoring a Competitive Economy. He's harking back to Robert Bork's Antitrust Paradox. But essentially, Professor Baker argues that antitrust swung too far in the pendulum, and that there are challenges, especially when intellectual property and information technologies and the like are involved. And we need to be more aggressive in trying to curb market power in these areas. He says the IT giants have likely achieved their positions, at least in part, quote, through combinations of network effect, IP protections, endogenous sunk costs, etc. So he calls for that. Tim Wu, The Curse of Bigness, Antitrust in the New Gilded Age, makes much the same point. And then, just to make sure that we don't stereotype people, Eric Posner and Glenn Weil have written a book called Radical Markets, Uprooting Capitalism and Democracy for a Just Society. It is kind of an out there book, I have to say. And if you haven't read it, it'll probably curl your hair, but it's kind of interesting. They're talking about concentrations in markets and saying that maybe we need, again, to take another look at this. Where I think we can, I wouldn't go as far as some of those people, but what I would say is that there are lessons to be learned on the IP side that might help antitrust thinking. And I'll just give you the one example before I sit down of standard essential patent licensing. You all know about that. SEPs, will be chosen by some kind of standard setting organization. Typically, there will be a requirement for licensing, the FRAND requirement, free and non-discriminatory, fair and whatever, it means fair and non-discriminatory royalties, access to this essential patent so that we can have the efficiencies of a uniform standard. I don't think anybody would argue that that's an invalid goal. You want the lamp to plug in when you buy it. You want things to work together. But the interesting comparison, I'll actually, with one of our colleagues, be interested, that's exactly the kind of thing the European courts are asking the giant companies to do. They're worried that companies like Google, which they've had a number of proceedings against in the Competition Directorate of the European Commission, have technologies, have platforms, have resources. Maybe it's the shopping platform, maybe it's another platform, and they're not allowing access to that platform from outsiders. No one's asking them to give it away, but essentially they're asking for FRAND-type access to these platforms. And you think, is that a promising way to deal with monopoly power? Well, if it's a good way to deal with it with IP, maybe it's a good way to deal with it with other property too. You would just have to think through that, because as I said, going back to that fundamental insight, intellectual property is property. It's just property that's a little harder to take a photograph of and put on the table. So we would be, if outside the IP context, I think quite skeptical. If I found out that all the competitors in a particular area sat down in a room and decided whose property they were going to use for something and what the price of that property was going to be, I might start getting heartburn. But we don't do that if it's a standard essential patent and if it's FRAND. So I think there may be some real synergies back and forth between the IP field and the antitrust field that would be well worth exploring. This is, again, on a substantive side, and that substantive exploration could take place much more effectively if we get rid of the siloed approach on the procedural side that we've used since 1982 and go back to allowing a more comprehensive look at intellectual property. So thank you.